Right. Alrighty, let's kick off. So I have started recording. I'm just on a laptop with no extra screen, so you might just have to excuse my clunkiness today. I am stretching the powers of my technological know-how. But rest assured, I know plenty of things about employee or contractor, which is what we're all here for. So, welcome along this morning. This is the 5th workshop in a series of workshops that we have been conducting around the changes to the Fair Work Act that have been happening over the last couple of years. This morning's session is all about whether or not somebody is an employee or contractor. There have been a few changes which make this particularly relevant for businesses that are thinking about or currently engaging independent contractors in their workforce. We have some great resources that we will share through an EDM in the next couple of days, and predominantly the contractor versus employee checklist. And these workshops are brought to you with thanks to the Australian Government Department of Employment and Workplace Relations through the Productivity, Education and Training Grant Fund program. Now, we've just found out that we've got some funding for next year as well, so we'll be able to keep bringing you these workshops free of charge, which is fantastic. For those of you that have just joined us, I'll just let you know we are recording. I will stop recording at the end of the session. If you have any questions you want to ask, you are more than welcome to do so whilst we're recording, or I will stop at the end if you would prefer to be offline. All right, so this morning we're going to cover off the new definition of employment. What is an independent contractor? We'll have a close look at the multi-factor test because this is what we're really using in terms of determining whether or not somebody is an employee or a contractor. We'll also have a quick look at the high income opt-out options. So there is a threshold at which people can actually opt out of this new definition of employment, which is good, but only really helps if you're employing people that are on sort of over $175,000 a year. And also, as always, we'll give you some information on where you can get some additional assistance from if you would like it. Quick disclaimer, this information is general in nature. If you have any specific circumstances, we're happy to chat to you about those, or you might like to use the person or the organisation that you usually get workplace relations advice from. And this really all came about with the change, with the closing the loopholes bill, which was introduced at the beginning of last year. It came into effect from the 26th of August 2024. And the purpose of this legislation is really about stopping businesses not employing staff. So when we think about the use of independent contractors, there is an opportunity, or was an opportunity, to find a loophole. And instead of employing people and abiding by the Fair Work Act, some businesses were effectively just engaging a whole bunch of independent contractors that weren't really contractors. It was just a way to get out of having to do all of the things that we have to do when we employ people, such as having workers' compensation insurance, payroll tax, superannuation obligations, and a whole raft of other things, as well as the fact that it's much easier to terminate an independent contractor than what it is to terminate an employee. So there's some real attraction for organisations that are looking to minimise their risk and don't want to have to deal with the Fair Work Act for them to just engage a whole bunch of independent contractors and avoid their obligations as an employer. And that really feeds into the Labor government looking to create more job security. And obviously, as an independent contractor, job security is quite isn't really there, whereas for an employee, there's a little bit more safety and security in that type of relationship. So the new definition is really about saying that they're looking past the contract. So prior to the change in the legislation, if you had a really well-worded independent contractor contract, that was considered to be sufficient to make sure that you wouldn't be in a bit of hot water if they should have been an employee. Now they'll be looking at the real substance, practical reality and true nature of the relationship. And if you've been to a few of these workshops, you would have heard that phrase before. It's also the test that they're using with casual employment as well. So the Fair Work Commission would be looking at how you're actually using that independent contractor in your business, and whether or not that relationship that you have, including the terms of the contract, but also how that contract is performed in practice. So if you're rostering your independent contractors on, they are working alongside your employees, performing the same kind of work as your employees, they are in fact an employee and most likely not a contractor. And one of the places I've seen this the most is in regional areas with Airbnb cleaners. So effectively, everybody that's engaged as an independent contractor is performing the same work. Most of them are only performing that work for one employer. And when you think about a cleaner, it's a fairly low-paid job. There's a perception and maybe a reality that those people are not really in a position to advocate for better employment conditions, and so they are much more likely to accept an independent contractor relationship instead of an employee-employer relationship, because they're actually just wanting work and they're wanting some money, and they're not really in a position to say, well, actually, I think I should be an employee, because of the risk of that employer saying, well, actually, don't worry about it. So when we're looking at this new definition, it's not just your independent contractor agreement that they'll be looking at, it's also how you use that contractor in your organisation. So independent contractors work for themselves and they provide services to another person or to another business. They can also be called contractors or subcontractors. And they're different from employees as they don't have those same rights and obligations as an employee in a business would. So it's important to note here, if you are using independent contractors, you should be paying them superannuation in addition to their contract fee. I think I've spoken to about half a dozen businesses in the last 6 months that were not aware that they have an obligation to pay superannuation to independent contractors. Now, I am not an accountant, so that is the extent of the advice that I can provide to you. But if that statement makes you go, oh, am I paying superannuation to my contractors? I strongly advise having a chat with your accountant or bookkeeper, because there's some nuances depending on how the independent contractor's business is structured. But you cannot include their superannuation payment in their invoice payment. It needs to be made by you on their behalf in addition to whatever their contract fee is. So just make a note if that's ringing some alarm bells for you. I would go and have a chat with your accountant or bookkeeper about that. So independent contractor agreements are still required, but they're not, you can't rely upon it. So an independent contractor arrangement should be supported by a comprehensive written agreement. And this is to protect your business as well as the independent contractor. So one of the tests of independent contractor versus employee is if the work is not completed to a standard that we expect, who is responsible for fixing it? So if you've got an independent contractor out there doing something for one of your clients and it all falls apart, who's paying to fix that? So in a proper independent contractor relationship, the independent contractor is responsible for the quality of their work, and they are also responsible for rectifying any issues with their work. But if you haven't got a good agreement, then it becomes a grey area. And so they can just as easily say, well, I thought that you would fix that, not me, or I'll go and fix it, but you have to pay me my hourly rate for me to go and fix it. And so an agreement allows us to be very clear about who's responsible for what. So it should have things like who the parties are to the contract, so your organisation and the contractor, what work is going to be done. So what are we actually engaging that independent contractor to do for us? How will we pay them? So is it an hourly rate? Is it a day rate? Is it a retainer arrangement? When are we going to pay it? How are we going to pay it? If any expenses are incurred during the independent contractors carrying out of work for you, who is responsible for those expenses? And that could be, maybe they're responsible for these things and you're responsible for some other expenses. If they develop something whilst they're independent contracting for you that you might like to commercialise, who owns that intellectual property? You would also have confidentiality agreements in place, particularly if they're dealing with your customers or clients. Insurance is another one. So generally speaking, independent contractors should have their own insurance. But there are some insurers who will cover independent contractors under some policies. Again, it's not something that you want to leave in a grey area, particularly if something goes wrong. We want to make sure that they've got professional indemnity and public liability insurance. The superannuation and taxation payments. If you are paying super and PAYG tax on behalf of your independent contractor, that is definitely something that the Fair Work would consider a tick in the box that they're actually an employee, not a contractor. So you might be doing that to be really nice and helpful to them, but in actual fact, it's going to work against you if it was ever questioned as to whether or not that person's a contractor or an employee. The other thing that you would like to include in that contract is whether or not the contractor can actually subcontract somebody else to do that work on their behalf. And the very important clause in there would be about what are we going to do if there's a dispute? How will we resolve that? So a good contractor agreement should have all of those things in it so that we're not wondering who's responsible, or worse still, assuming that they're going to be responsible and then they assume that you're responsible, and that's when you will have a dispute. And if you haven't got a dispute resolution process, that can make things very messy. All right, so that's your independent contractor agreement. For those of you that have joined us, I will just let you know we are recording the session. So if you want to ask any questions, you are more than welcome to, or we can have an opportunity at the end for you to do that. So the multi-factor test is back. If you've been in this space for a few years, then you would be familiar with the multi-factor test, but it is definitely back. And even with this test, there's no definitive way to determine. It's quite broad ranging. It will consider that contract, but it will also consider how that contract is performed in practice. And there isn't a real weighting given to each factor. So you can't go, if I tick box 6, 7 and 8, then they're definitely a contractor. It's really about common sense and I suppose the nature of the relationship that you have with them. So these factors are a guide, but obviously we'll send you the checklist. The more boxes you can tick in the independent contractor column, the more confidence that you can have that this is actually a genuine independent contractor relationship and not something that could be an employment relationship. So we have had a couple of businesses, and one in particular that I'm thinking of, they had an independent contractor arrangement with one of their, with an individual in their organisation. And it was all fine until that contractor, I kept going to call them an employee, that contractor was in some financial difficulty, and they had obviously done a little bit of research and realised that they could potentially claim that they were in fact an employee. And so they're now suing their employer for, I think it's about $180,000 worth of leave entitlements. And everything was fine in that relationship until it wasn't. And there was no independent contractor agreement in place. The employer was paying superannuation and tax on behalf of that contractor. And so now they have a very expensive legal battle that they're currently engaged in to hopefully prove that there was an independent contractor relationship there. And even if there was, the stress and the expense of having to defend something like that takes a big toll on our mental health and our ability to actually focus on running our businesses. So the things that are in this multi-factor test, this is about contract terms. So contract terms that indicate an employment relationship is that the worker is remunerated by time worked or salary. So they're on an hourly rate or a weekly rate. The worker is not permitted to perform services for others without permission from you. The worker is acting on behalf of the company. So in fact, the worker looks and feels like they belong to your organisation, not their own organisation. If you're paying income tax for them or deducting income tax for them, if they're not allowed to delegate work to others or subcontract work to others, and if you're providing all the tools and equipment for that worker. So as I said to you before, not one of these is definitive. These are a guide only. So the more boxes that you check here, the more likely it is that that employee, that person or that worker might be considered to be a contractor. But there are a bunch of other factors we're going to look at in just a minute. So the other contract terms that indicate there is an employment relationship include the worker's ordinary hours are set out in the contract, like they would be in an employment contract. The company has the right to suspend or dismiss the worker, like they would with an employee. the company remains liable for remedying any faulty work of the worker. So this is one of the reasons that I would find an independent contractor relationship quite attractive in that sense, is that if they stuff it up, they've got to pay to fix it. I'm not dealing with the cost of rectifying any faulty work. If your worker is entitled to paid leave, there absolutely is a tick in the box of that, of them being an employee, not an independent contractor. And if the company is determining when, how, and where the services of the worker are performed, again, it's a tick in the box that it is probably an employment relationship, not a contractor relationship. So some additional contract terms that indicate a contractor, the contract terms that indicate a contractor relationship. Sorry, get my words right. So if you're paying your contractor based on goods or services delivered or paid on results, that is a tick in the box of independent contractor. If you're paying GST on invoices issued by the worker, if the worker is expressly permitted to work for other organisations in their own business, the worker's company issues invoices for services performed, and the worker is expressly permitted to subcontract or delegate that work that you're engaging them for. So these things would indicate, not guarantee, that you have a contractor relationship, and they're leaning against that person being an employee. So we're paying them based on output or results. We pay GST, they give us an invoice. They're allowed to perform their specialised work or services for other organisations, and they can also engage a subcontractor to perform that work instead of them. Some other factors that also indicate a contractor relationship include that the worker is not permitted to act on behalf of the company or make decisions on behalf of your business. They're able to select their hours of work to perform the tasks. So that will depend. Obviously, if you're running you're running a business and somebody's a contractor to come in and do your cleaning, then you're probably not going to want them running around with the vacuum cleaner in the middle of office hours. But effectively, they could come between 6 o'clock at night and 7 o'clock in the morning, and it wouldn't matter what time they showed up. They get to decide. The contract with the worker could be terminated for a breach of contract. So that's that independent contractor. If they've breached the agreement that you have with them, then you could terminate them from your organisation or from providing services to you. The worker is required to provide some equipment and tools to perform their job. They're not entitled to paid leave, and they're responsible for the quality of their own work. So it's kind of the opposite of the things that we were talking about in the previous slides. So when you start thinking about these holistically, you can really start to paint a picture of whether or not somebody might be a contractor or an employee. And there's a few other factors that we still need to consider as well. So if you don't have a written agreement, the things that they would be looking for in terms of determining the nature of the relationship would be the type and consistency of service. So if you're engaging an independent contractor to come and, I don't know, mow your lawns or trim your hedges or do your payroll or do your social media or whole bunch, like something that your business does not do as your core business. So it's a service provider providing an expert service into your business that is not part of your core business, then that starts to reinforce that it is an independent contractor relationship. However, if you've got people in your business independent contractors in your business providing the same types of services that you are paying employees to deliver, then all of a sudden it starts to become a bit questionable as to whether or not that person is an independent contractor. If you are, if they have to apply for leave with you and they can't perform that service while they're on leave, the amount of direction and control that you have over the work that they're performing. So obviously if somebody's an independent contractor and they're doing things for you that you don't know how to do and that's why you've engaged them, then that also makes a good argument that they're an independent contractor. How does that worker present to the world at large? So if they're wearing your uniform, driving around in your cars, sitting at your desks in your office, then the world at large would consider them to be an employee of yours. Whereas if I'm showing up in my TCCI branded vehicle and I'm coming in to deliver some training for your organisation and I'm going off to do that for somebody else and you haven't told me how to deliver my training, then all of a sudden I start to look more like an independent contractor. Equipment, uniform and PPE, if they're providing most of those things themselves and they're not wearing your uniform, again, it sort of looks more like an independent contractor. How you pay them, how your tax arrangements and rewards work is also something that we'd be looking at. And then who bears the commercial risk in that relationship. So see why having an independent agreement is very good for these types of things. So just a few dot points on each of those areas. So the type and consistency of the service. So if they're working regular hours or there's an expectation they're going to show up on certain days and for certain periods of time. These are employee-like factors. If the worker has an expectation of consistent ongoing work with the company with no anticipated end date. If the work being performed does not involve a profession, a trade, or a distinct calling on the part of the worker. So that's that specialist knowledge that doesn't necessarily exist in your business. If the worker is providing a service that is central to the company. So I'll just reinforce that none of these are definitive, and it's really about looking at holistically, taking into account all of this information. So as I said, if they're taking leave, like sick leave and holiday leave and compassionate leave, and it's paid for by the company, very much employee-like. And when they're sick, the business waits for them to recover. So that's where that subcontracting or delegating the work comes in. So if we kind of just hold off until our contractor comes back to work, it's an employee-like factor. The direction and control is really about how much right you have, or how in practice you control the how, when and where the work is performed by the worker. The company is monitoring and supervising the work. The worker works only for your company. You can determine what work the subcontractor can delegate or subcontract out. And the company is monitoring and providing feedback to the worker during the performance of the work. All of these things are employee-like factors. So if you're starting to tick a lot of those boxes, you might need to consider whether or not it is in fact an independent contractor relationship. So how the worker presents to the world at large. As I said, basically they look and feel like they're one of your employees. So they present as if they work for you. They don't have the opportunity to build a reputation about their business separate to the company. The business advertises the goods and services of the worker to the world. So they're performing that contract work under the umbrella of your brand. The worker doesn't have business cards is issued business cards by your company. So if they've got their own business cards with their business name that they give out to people, then that looks and feels to the world like they've got their own business. But if they're handing out one of your business cards, they kind of look like one of your employees. I will say the exception to this is that high income test. So we've worked with a few consulting firms that engage engineers and project managers and those sorts of things. And so those contractors do, in fact, look and feel like that business, but they meet the high income opt-out clause. So if they like being a contractor and they want to stay being a contractor, then they can just send their employer an email and say, hey, I'm quite happy with this arrangement and I don't want it to change. And medical centres are another one where often the doctors are independent contractors engaged by the medical centre. And again, most of those doctors would be over the high income threshold. So if they like that arrangement, they can keep it, even if they don't meet the test. So things like company email and those sorts of things. So it really varies by job type and industry, and also how much somebody's earning. This one is, as I said before, if you're providing all of their uniform equipment and PPE, it certainly looks and feels like they're an employee of yours, not necessarily a contractor. Remuneration. So if we are, thank you to whoever let that person in. If we're remunerating them by time worked or on a salary, that's an employee-like factor. If the worker is a sole trader, is another factor that we're looking at. Yes, if we're paying them on time worked, if you're deducting income tax from their remuneration, if you're paying for their public liability, workers' comp and professional indemnity insurance, and if the work of that worker creates goodwill or saleable assets for your business, it is an employee-like factor or a tick in the employee column, not the independent contractor column. I've already talked about that commercial risk. So you, as the organisation contracting them, does not bear the cost of fixing their work. And if you are responsible for the cost of fixing their work or liable for anything that doesn't meet your customer or the standards, that's an employee-like factor. So before deciding, practically speaking, is the person performing the work an entrepreneur who owns and operates a business? And in performing that work, is that person working in and for that person's business as a representative of their business and not of your business receiving the work? If the answer is yes, the person is likely to be an independent contractor. If no, then the person is likely to be an employee. So are they running their own business, doing those things for themselves, for other organisations? Then it's definitely leaning towards that independent contractor. But if you can't say yes to those, then I would be very much considering that they could potentially be an employee. So the last section is really about that high income opt-out. So as at the 1st of July last year, it was $175,000. It gets reviewed annually, and I imagine that when we have the wage decision from Fair Work, we will also get an increase to this 175. I will say that that is their combined income. So if they're contracting to you and another couple of organisations, and you don't know what their combined annual income is, I would just be sending them an email to let them know that this new legislation's come into place. If you're earning through your business more than $175,000 a year, you've got the right to opt out of this. And they've got 21 days to advise if they wish to take up the opt-out clause. And they can also withdraw that at any time and request to become an employee if they meet those employee-like factors. Now, this is not something we want to get wrong because it's expensive. If somebody's been misclassified as an independent contractor, they may have a claim for back pay and employment-based entitlements. It's a bit like that example I was giving you before about the person that was a contractor, they were happy to be a contractor and something changed. And then they realised that they had an angle that they could take that actually, no, I wasn't a contractor and now I'd like all of my leave entitlements from the dawn of time. So entitlements for these workers began accruing from the 27th of February last year. So if somebody was found now to be an employee, not a contractor, and they were misclassified, or the business knowingly did that, then there's a likelihood that the business is going to be liable for leave entitlements for, what are we up to now, about 16 months. And if an employer does this knowingly, they may face penalties for engaging in sham contracting. So there are some employers around that may be doing this deliberately. And if it is proven that they've been doing it deliberately, I would not want to be on the receiving end of that, because I would suggest that Fair Work will make quite the example of the first case that they had in this space. So as always, we're here to help. The Fair Work Ombudsman was also available to help. And if you have less than 19 full-time equivalent employees, then we can help you at no cost through the Employer of Choice Assist program. This is something we've been doing with a lot of small businesses, is helping them identify who is an employee and who is a contractor. Yes, so that's funded by the Department of State Growth, Jobs Tasmania, and delivered through the TCCI. So I'm sure you're all sick of listening to me talk now. We will send you a feedback link. As this is government funded, we do like to send the government some feedback to let them know that we are doing all the right things. So if you would like to provide feedback, you can scan that QR code, or you can click the link when we send you an email. All right, let's see if we have some questions. I'm just going to stop recording. All righty.